Institute for Global Security, Law, and Policy here at Case Western. We are part of the Frederick K. Cox International Law Center. On behalf of both the Institute and the Cox Center, I welcome you. It is my great pleasure to be able to introduce a former student of mine, a graduate of Case Western, Lieutenant Commander Brian Mizer. Lieutenant Commander Mizer is currently at the Office of Chief Defense Counsel for Military Commissions, has served as the military defense lawyer for Salim Hamdan, and also for Mr. Aziz Ali, who is Sheikh Khalid Mohammed's nephew. And he will be speaking today on U.S. v. Hamdan, Military Commissions 66 years after Quirin.
Thank you. I'd like to thank Professor Strassfeld and Case Western for extending me this opportunity to come and address you on this important topic, to have this important discussion. I must start this talk, as I start all talks, with a disclaimer that though I'm here in uniform, I represent two clients that are charged before the Military Commission. It should be no surprise to you that my views are not those of the United States government, nor will they ever be while I'm a defense counsel. Groucho Marx once said that military justice is to justice as military music is to music. And while I think that there is that perception in American culture, the reality is quite different. Modern military justice provides a robust set of rights that are often more protective of an accused than you would see in a state or federal court. Article 32 of our Uniform Code of Military Justice provides a pretrial hearing where the accused can be present. It's a great discovery tool. If you've ever litigated or seen one of these courts, you have the right to challenge the government's evidence, including cross-examine witnesses. Another example is Article 31. When Professor Katz has you read the Miranda decision this year, take a look at that decision, and you'll see Chief Justice Earl Warren cite a number of jurisdictions, one of which is the United States military, which in 1966, when Miranda was decided, had been providing Miranda rights since 1950 under the Uniform Code of Military Justice. And the argument was, if we can do this in the military, why can't we in Cleveland, Ohio, in Arizona, provide Miranda rights? F. Lee Bailey, who has done quite a bit of litigation in courts martial dating back to the 1960s, once said that if he was guilty, he would prefer to be tried in federal court, but if he was innocent, military justice was superior. Now, he's obviously joking, but the one point that I think that you must take away today, if nothing else, is that military justice is a superb system of justice, and what is happening at Guantanamo Bay is neither justice nor military justice. And I will argue that it is not even a military commission. If you read the Supreme Court's decision in Hamdan versus Rumsfeld, you will see Winthrop quoted extensively, and the Supreme Court has called Winthrop the Blackstone of military justice. And it is laid out eloquently in that opinion how military commissions have always been a battlefield expedient, how they have always paralleled courts martial, or it's the military equivalent. So courts martial and military commissions have been the same, uniform, if you will, in procedure, with one glaring exception, or two, the Quirin military commission, and then also the military commission that was used to try the Lincoln conspirators. The military commissions at Guantanamo Bay are not occurring on a battlefield, and they do not resemble the Uniform Code of Military Justice. I think it's interesting. Colonel Mo Davis, the former chief prosecutor who has resigned over unlawful influence of the proceedings at Guantanamo Bay, has testified in Hamdan's case that when it came time to draft the manual for military commissions, that the military was excluded, which should be astonishing given that it is supposedly a military proceeding. The manual was drafted by civilian attorneys, the Department of Justice, and the Central Intelligence Agency. Mo Davis always has great one-liners, and I think the one that he used in Hamdan's testimony was that the military commissions are federal court light. And I think that that's probably as best as it can be described. The chief prosecutors are typically from the Department of Justice. I'm litigating, as Professor Strasfeld said, the 9/11 case. It's a joint case involving 5 of the alleged 9/11 co-conspirators. And in that case, I believe that there's 7 attorneys that have made appearances. Only one of them is a military member, a Marine major, whose only words on the record have been to identify his name for the record. The civilians have done all of the other litigation. Those proponents that would tell you, and there are some in the employ of the government, that will tell you that the military commissions are like the UCMJ, are technically correct in that the Military Commissions Act is the UCMJ with all of the substantive rights for an accused removed, or most of the rights for an accused removed. If the military commissions are not military commissions, that battlefield expedient, if they're not military justice, then what are they? And I suggest that they're a national security court. A national security court in olive drab with military window dressing, but not in fact a true military commission. And I'll return to the idea of national security court a little bit later this afternoon. First, I want to address how we got here. 7 years of litigation, millions of dollars spent, and 3 convictions, only 1 contested, in a system that is universally recognized as a failure. I don't know that there's any serious debate going on now that the military commissions should be continued in their current form. And most of that failure can be attributed to the government's steadfast reliance on ex parte Quirin, a few other decisions, Eisentrager and the Yamashita decision as well. Which is really remarkable if you look beyond the opinion. I think that there were some materials included today. If you look at really the facts of Quirin, those things that aren't set forth in Quirin itself, it is really astonishing that you would take Quirin, that you would take Yamashita, that you would take Eisentrager, and then build a modern legal system upon those decisions. I think the article that was included here, the Keystone Commandos, really captures these saboteurs, 4 of whom are behind me here. Hans Herbert Haupt, the youngest of the group, left Chicago because he had gotten his girlfriend pregnant, fled to Mexico, joined the Nazi Party, and then went to Germany. Now the real spies had been captured in the United States. We broke up a real spy ring in 1940, and so Hitler put together these 8 guys as a kind of a crackpot scheme to land saboteurs. An operation that was doomed to failure from the beginning. I mean, here you have the other 4. These are the gentlemen that were landed up in Amagansett, Long Island. Richard Quirin there at the bottom. George John Dash, Ernest Peter Berger, is the 2nd American citizen, although you won't see that referenced in the Quirin opinion. George Dash turns in the entire group within days of landing in New York. The FBI promised him a presidential pardon as part of his cooperation, something that if you read the testimony at his capital trial, you will see the FBI agent admit to. Yeah, that's pretty much what happened. We did promise him a presidential pardon if he would cooperate with us, and that's right, he's here on trial for capital offenses. There was a problem that the government faced in Quirin that I think you will see later when the decision is made to have military commissions. Again, the saboteurs had not really committed any acts of sabotage. I mean, the 22-year-old Haupt had taken some of his sabotage money and bought a 1941 Pontiac sports coupe. That was the closest that he had come to committing acts of sabotage. There was the mention of the pardon, but there was also the issue of how do you try these individuals? The maximum punishment was 3 years. You could probably get these guys under some sort of a conspiracy, the general federal conspiracy statute, but that was it. And so, really, the commissions in Quirin's case is an attempt to circumvent the law and to increase the punishment, something that is being done right now at the military commissions under the Military Commissions Act. Hearsay was permitted. And strangely enough, the case is actually prosecuted by the Attorney General himself and the Judge Advocate General of the Army, handpicked by the President of the United States. Now, the Judge Advocate General of the Army, under the Articles of War, the predecessor to the Uniform Code of Military Justice, was supposed to review any conviction, any military conviction, whether it's commission or UCMJ, and that's one of the issues that you will see in the Quirin opinion is the departure from the Articles of War. 42 days after these men landed in Florida and New York, they were executed. That's how fast this trial went. One of them, Haupt, on the first slide there, was again an American citizen. This is, I believe, the only known photograph of that military commission. I'll have this put up a little bit later because when the first version of the military commissions are enacted by executive order in 2002, I mean they actually replicate the furniture, not just the procedures. I mean, they go through and, I mean, this is what a military commission looks like. We've got to get the table straight and the chairs, and then 42 days from now we'll have convictions and be on our way. That would be the Groucho Marx understanding of military justice. This is Kenneth Royal. He's the last Secretary of War, the first Secretary of the Army. And if you read the legislative history of the Uniform Code of Military Justice that is put together by the JAG School in Charlottesville, you'll see his name mentioned. He's there as the Uniform Code is being drafted. I mention him because he's also Quirin's defense counsel. So he's one of the 3 lawyers that were appointed for those for the 7 saboteurs. Dash, because he cooperated, got his own lawyer. If they weren't going to grant him the pardon that he had been promised, they would at least give him his own lawyer. And the code really is a departure from previous military practice. We don't even know how many soldiers were executed in World War II because the military justice was so terrible. And the Uniform Code is really a marked departure from prior practice, the Articles of War, and it will be uniform. There will no longer be regulations for the Navy and separate regulations for the Army and the Army Air Corps at the time. They will be uniform. Interestingly enough, Article 21 and Article 36 of the Uniform Code of Military Justice require uniform procedures regardless of the military tribunal. So it requires commissions to be to enact the same procedures as the Uniform Code courts-martial unless deviation can be justified. Those 2 statutory provisions would later become one of the central points in Hamdan's appeal. You can't deviate from the Uniform Code of Military Justice in enacting this commission. So you had Quirin's defense counsel essentially assisting in the codification of the prohibition of the deviation that happened in Quirin. The code bolstered rights. In 1949, we had the Geneva Conventions that occupied the field in international law. There would no longer be the category of persons in Quirin unlawful enemy combatants. There were combatants and there were civilians after 1949. There were numerous opinions with respect to civil liberties in the Warren Court, and of course, I think importantly, the murdering spouses cases of the late 1950s and 1960s, where the Supreme Court said that civilians accompanying the armed forces in Germany were not subject to military trials. All of these are important. The chief among those cases is Reed v. Covert, which you'll see again in Boumediene this term. It's one of the cases that Justice Kennedy relies upon for the idea that the Constitution applies outside of the territory of the United States. Yeah, in March 2002, President Bush ignored 60 years of the evolution of domestic and international law and enacted essentially a carbon copy of FDR's order in the Quirin case. Much as President Roosevelt's, I guess similar to President Roosevelt's order, President Bush's order, summarizing here, says that the commission can make up the procedure as it goes along, just get the commission going. And then it also specifically permits hearsay. FDR's order, the only difference on that respect is FDR's order says reasonably probative, probative to a reasonable man, and President Bush's order says probative to a reasonable person. That's the distinction. Because if you're going to deny rights, you should be politically correct about it. I think that's the lesson to take away. The major distinction between the orders is that the jurisdiction was much broader. Whereas President Roosevelt's order subjected foreign nationals of a state with which we were at war, who had been captured on U.S. soil to military commissions, President Bush's order generally extended to anyone who was supporting terrorism, committing terrorism anywhere on the globe. Thus, the global war on terror. Mr. Hamdan was captured as part of that global war on terror. You see here, I mean, he's a Yemeni with a fourth grade education. He drove a Dabab, which is like a Cushman in Sana'a, Yemen. Driver between 1996 and 2001. He's captured in 2001. This is a photo, actually one of the prosecution exhibits at Mr. Hamdan's trial. You can see Osama bin Laden is kneeling there with his head covered. Mr. Hamdan is over there, over here to the left. The far right is Osama bin Laden's #1 bodyguard, a man by the name of Tabarak. He was released from Guantanamo Bay in 2006. And then his #2 bodyguard is actually Mr. Hamdan's brother-in-law. He's a Yemeni by the name of Nasser al-Bahri. He was detained without charge in Yemen for 2 years, and the United States has never attempted to seek his extradition, to my knowledge. But we did get the driver, Mr. Hamdan, there on the left. Here's Mr. Hamdan in April of 1998 at a press conference. This is, of course, Osama bin Laden and Mr. Hamdan there in the center. So on November 24th, 2001, Al-Qaeda's in retreat. Osama bin Laden has gone towards Tora Bora. Mr. Hamdan takes an Al-Qaeda car and drives his family to the border with Pakistan. He has plane tickets to leave Pakistan. He drops his family off and is headed back to return the car when he is apprehended by an Afghan force that was, I'm trying to figure out how to say this precisely. There were Americans present with the Afghan force. Now the Americans were Americans, and they didn't want to be seen by the locals. This was supposed to be perceived to be an Afghan assault, and so the Americans were kept largely out of sight, which will become important for Mr. Hamdan's trial. This is Highway 4. This is what a highway looks like in Afghanistan. This is the road and the town of Takhtapol, just north of this checkpoint. More views of Takhtapol. This is actually, I'm told that this is the Toyota Corolla there in the distance that Mr. Hamdan was driving in. These are actually 120 millimeter rocket rounds that are coming in on this Afghan force. So I just want you to get the sense that this is an active zone of hostilities where Mr. Hamdan was captured. There's another shot of the Corolla, more shots of the rockets. And these are the SA-7 missiles that were allegedly captured in Mr. Hamdan's car. I say allegedly because we did beat that charge at Mr. Hamdan's commission, although to hear the government talk to this day, they're still talking about these missiles and Mr. Hamdan being caught with them. So Mr. Hamdan is taken into custody on November 24th, 2001. As I said, he's interrogated by Americans. This is a still from that videotape. He's kept there for about 7 days before he's flown somewhere. Now, I don't know where he was flown, because we attempted through the discovery process to find out where Mr. Hamdan went on or about December 1st, 2001, and the judge declined to order the government to disclose that to us. So I have the unique experience of being in a criminal case where the government takes your client somewhere and you have no idea where that is. I do know that he showed up at Bagram Air Base on December 28th, 2001, so there is a month that we have referred to as the black hole, where Mr. Hamdan goes, and we don't know. Mr. Hamdan did testify under oath that he was taken somewhere. Now, he was hooded, as you see here, so he doesn't know exactly where he was beaten by men with Egyptian accents while they questioned him about Egyptian members of Islamic Jihad and Al-Qaeda. Specifically a technique where they would push, he would sit with his legs crossed, and one man on each side would put a boot on his knees and pull his arms up behind his back while asking him these questions. If we could turn the webcast off just for this next slide. So by the time he gets to Bagram Air Base, Mr. Hamdan is more than willing to help the United States government. He identifies 50 members of Al-Qaeda. He's then transferred to Kandahar, where FBI interrogators, two of whom you'll see there on the left, I don't know who the gentlemen are on the right, take Mr. Hamdan on two tours of Kandahar. So Mr. Hamdan shows them where Osama bin Laden's safe houses are. He shows them where Abu Hafs al-Masri, I think it translates to Swift Sword or Sword of Justice, the military commander, one of those that was involved in the planning of 9/11. He shows where his body was buried. He was killed in an American airstrike. And he does this twice, shows maps and provides valuable intelligence information to the United States. He provides 42 interrogations, 42 statements to the FBI and other governmental organizations. And when I think about Hamdan, I think about George Dash, who, when he lands here in New York, says, I'm not really a Nazi. I'm going to go and turn myself into the FBI, and who is then prosecuted. It's very similar to what has happened to Mr. Hamdan. I mean, I don't know that you would find anyone else at that prison camp who has probably cooperated more, and even to a classified extent. I can't. There's even an additional incident that is classified that was key to our defense case, which was classified at his trial. You can go ahead and put the camera back on. Now, we know what happened in Hamdan versus Rumsfeld, and I'm not going to go into that. But just generally, the Supreme Court said that the first set of military commissions that tried Mr. Hamdan was illegal. The Supreme Court's words, not mine. The court said that absent congressional approval, military commissions must comply with those articles that were drafted by Kenneth Royal and the Congress in 1949 and 48. And they also must comply to the Geneva Conventions, and the Geneva Convention did apply to Mr. Hamdan. And so then we get to the Military Commissions Act of 2006. Now remember, the original executive order permitted hearsay. Congress then codified that permissible use of hearsay, and the burden is on the accused to show that the hearsay is unreliable. Which is an almost impossible task. Remember those missiles that I showed you, those two SA-7 missiles that were allegedly found in Mr. Hamdan's possession. What happens is there's a roadblock. We know that one Toyota Corolla, believe it or not, I mean, you actually have two Toyota Corollas drive up at a roadblock in Afghanistan. I mean, this should be a law school exam question. The Arab, according to the hearsay from the Afghans that were at the checkpoint, the Arab gets out of that car, pulls a grenade, fights to the death, and the grenade doesn't go off, and the Afghans kill him. Mr. Hamdan, who has these missiles and also 2 Kalashnikovs, jumps out of his car and runs off into the desert crying. And according to the second-hand version that I have from some of the Special Forces individuals, the Afghan warlord sits there and laughs at him with some of his gunmen because there's a pretty heavy-set guy running off into the desert, and they can't quite make this out. I mean, where's this guy going to go? They let him get a couple hundred yards away, and then they chase him down and drag him back. A third van pulls up, and the 3 Arabs in there fight to the death, one of whom is captured with Mr. Hamdan. And so that's the entire capture story. So no one really saw Mr. Hamdan with the missiles, but they told a Special Forces soldier who came in and told a jury that the Special Forces, or that the Afghan told me that the missiles were in Mr. Hamdan's car, and that passes for evidence at a military commission. There is a right to remain silent codified in the Military Commissions Act, and you'll hear the government reference that, but it exists or extends only inside the courtroom. So your right to remain silent doesn't exist outside of the courtroom, which is the very purpose of Miranda. That what is the point of a right to remain silent if it doesn't exist outside of the courtroom? Stunningly, statements taken by physical coercion are admitted if they were taken before the Detainee Treatment Act of 2005. So you can have statements that were literally beaten out of an accused if that does not constitute torture. And that's where the litigation is going to head should the military commissions continue. I mean, what is the difference between physical coercion and torture? In Hamdan's case, we were given a number of documents on the night before trial. We had been seeking the confinement records for Mr. Hamdan for a year. The government had insisted that they did not exist, and so the night before trial, they gave us 1,200 pages of documents in a paper box. So we found them, and we weren't about to get a continuance. We asked the judge. So we had to lay all of these out. Fortunately, we had some spare attorneys at the time, plussing up for the 80 cases that the government intends to bring, and we laid all of these documents out on the floor, and on one sheet of paper was an entry that said that Mr. Hamdan entered Operation Sandman from June to July. It was a period of 50 days, and we're like, well, what is Operation Sandman? And we got online and started to do some research that night, and it's a sleep deprivation program. And so the government, of the 42 statements that the government took from Mr. Hamdan that we know about, the key interrogation happens during this 51-day period of sleep deprivation, where Mr. Hamdan had denied pledging bayat, this medieval loyalty oath to Osama bin Laden, on a number of other occasions, but during this period of sleep deprivation, Mr. Hamdan allegedly admitted to pledging bayat. And this statement was also allowed to be introduced through the testimony of FBI agents. I think it was interesting, and I do want to point out that I think the FBI agents and the Naval Criminal Investigative Service agents were completely unaware of what was going on. What we didn't see in Hamdan were the military interrogators. We didn't see other governmental agency interrogators, and it would appear that the FBI was just flown down to take these statements and weren't aware that Mr. Hamdan was kept in solitary confinement, that military interrogators had subjected him to sexual humiliation, sleep deprivation, and various other forms of coercive treatment. One of the other problems with Mr. Hamdan's trial is that the MCA permits the circumvention of the ex post facto clause. Unlike the Uniform Code of Military Justice, the offenses set forth in the Military Commissions Act aren't affirmative declarations of law. The MCA merely permits punishment for existing crimes under international law. And that was Congress's attempt to circumvent the ex post facto clause, and then they invent crimes under international law. They say that these crimes exist under international law, one of which is conspiracy, and the other is material support. Now, you can at least have an argument, I think, in fairness to the government, that conspiracy is a war crime. 4 justices of the Supreme Court in Mr. Hamdan's case said that it is not. And we will ultimately have to litigate that case in another context. But I don't think that there is any law of war expert who will say that material support for terrorism is an established war crime. It may be something that we want to develop, but it did not and does not exist. The Congressional Research Service, in a paper to Congress when they were drafting the Military Commissions Act, said so, and that's available online. I think it's somewhat ironic, I mean, just as a side note, that Mr. Hamdan, when he took his case to the Supreme Court, there was only one charge, it's conspiracy. And so when he wins the case at the Supreme Court, Congress makes more offenses, and that's what he stands convicted of now. So by winning at the Supreme Court, Congress created material support for terrorism as a crime. He was acquitted of conspiracy at his court-martial, the most serious offenses in July, and now stands convicted of one specification of material support for terrorism by driving and then also being an armed bodyguard, which you saw there, an armed driver. Excuse me. Trial began at the exact same time, just by coincidence, that Quirin was going on. Both trials take place in July, something that I didn't realize until a few weeks after the trial, when I emerged from the haze that was that 6-week experience. Still, the government argues, even after Boumediene. Remember that the case takes place 3 weeks after Boumediene. And the position of the United States is the Constitution applies at Guantanamo Bay because the Supreme Court in Boumediene says that it does, but only one sentence of the Constitution applies at Guantanamo Bay. So only that specific sentence which deals with habeas corpus applies at Guantanamo Bay. The rest is not applicable. So Article 1, Section 9, Clause 2, which deals with habeas, is applicable, but Clause 3, which deals with ex post facto violations of law, is not applicable. And so far, the military judges at Guantanamo Bay have universally accepted that provision. So the Fifth Amendment right to remain silent, the Sixth Amendment right to confront your accusers, none of these rights, these fundamental trial rights, apply. And so we had the hearsay dealing with the missiles and various other issues. We had statements taken by physical coercion. One of the other problems is you can't show your client classified information. And so although the government will give you discovery, and there were several documents that were particularly useful, I was not permitted to share those with Mr. Hamdan and say, hey, what do you think about this? I mean, can we plan our trial strategy on this? The only time that a prisoner gets to see classified information is if it's admitted at court. So what you have to do is have the document admitted and then have that discussion with your client. Would it be a good idea to have this shown to the jurors? No, because it's already up there on the screen. It's been published. We have a high-tech courtroom where each juror has their own screen down there at Guantanamo Bay. There's also an abuse of the classification process. One of the special agents that we were trying to cross-examine during the trial had testified inconsistently with the 9/11 report. And so Harry Schneider from Perkins Coie, my co-counsel on this case, put up the 9/11 report on the Elmo or the Wolf, blew it up there. The agent was getting ready to answer the questions, and the government asserted the national security privilege. And we were just somewhat baffled because I had bought this thing at Barnes & Noble before going down there, and the judge sustained it. So there has been a massive breach of security, if that were true, in the United States, because we're handing out this supposed classified information at bookstores. We also sought access to the 9/11 detainees. Just by way of reference, I mean, this is what the low-value detainee courtroom looks like. It's an old control tower there. This is to give you an idea of how long we've held Guantanamo Bay. This photo is taken from a Zeppelin hangar up the hill. This whole thing sits on an abandoned airstrip. This is that photo that I told you. I mean, this is a photo from the original commissions. You can see how they took the 7 chairs, everything, and just set it back up. More flags now. That's the big difference. This is the HVD courtroom, and you can see that it was designed with 6 tables, which just by mere coincidence is the exact number of people that were initially charged in the 9/11 case. This is taken back behind a glass panel. This is where the media sits. This is where the public sits. And everything that goes out into this spectator's box is on a 40-second delay. So once someone says something that's classified, a switch is hit. Now they've actually installed a light. So there's like a blue light special that goes off at the court security officer's desk up in front, so that we know that national security has been invoked. I mean, so if you don't believe me, I mean, here's the article from the New York Times where we're discussing the 9/11 report. So one of the other critical aspects of our defense was to seek access to certain high-value detainees. Now remember, Mr. Hamdan was charged with conspiracy under the broadest theory of conspiracy legally possible, I think. The government charged Mr. Hamdan with every terror attack that Al-Qaeda has ever launched. So he was charged with conspiracy to commit the embassy bombings, the Cole, and 9/11. And so we said, very matter-of-factly, well, we have some of the people that the government claims are actually involved in that conspiracy, and so we want to talk to Khalid Sheikh Mohammed and find out when Mr. Hamdan entered into an agreement to commit 9/11 and what overt act he took with the specific intent to commit mass murder. Because, I mean, if you actually look at the elements of conspiracy, this thing very quickly breaks down, that this is really a guilt by association case. And really not a valid criminal charge, something that ultimately the military members agreed with us. And so we sought access to some of those men, and the government fought us for months and months and months on access to these high-value detainees. We could not possibly speak to a high-value detainee because it would destroy the nation's security, and they continued to do this. Now, I should tell you, I have a top-secret security clearance, obviously. That with the 9/11 case, you have to have that level of clearance. And so the 9/11 arraignment happens in June. Hamdan's trial, as I said, is in July. So at the 9/11 arraignment, I'm there in the presence of four of the 5. The only one I didn't ask to speak to happened to be my new client. So I'm there with the 4 of the other 5. I actually had a discussion with Benatosh and with Khalid Sheikh Mohammed at that hearing. And we are then back in court 2 weeks later, and the government still says that I can't be in the presence of a high-value detainee because it will destroy the national security of the United States. In fact, their exact words were, we had used the analogy that the government keeps claiming that the sky is going to fall if I am allowed to go and speak with a high-value detainee about Hamdan's involvement, not about CIA custody, not about anything that would be classified, but about Hamdan's involvement in conspiracies. And the government's response was, quote, it's not buildings, or it's not the sky that's going to fall, it's another building that will fall, end quote. Now, I mean, the government's responses are absurd, and I think this is probably a good point to say, you know, there are a lot of good people on the prosecution side. There are a lot of good people trying their best from the military bench, but they're being placed in an impossible situation here and having to make tough calls. They're doing what their client has asked them to do, and in this case, it is to fight access to these men and to the CIA's program. As bad as all of that is, I think one of the worst aspects of the military commission is that the government has said it doesn't intend to honor the verdict. And so you may or may not know, Mr. Hamdan was sentenced to 66 months of confinement, which means that he should be released on December 28th of this year. So we're waiting for Mr. Hamdan's release here in approximately a month. The government, within hours of this sentence being handed down, asserted that it had the authority to hold him as an unlawful enemy combatant. And so he was an unlawful enemy combatant according to the government, then he's in a judge prisoner, and then he goes back to being an unlawful enemy combatant. And there is no point to holding these trials. In fact, they are nothing but show trials if we are not going to honor the verdict of these military commissions, because future dangerousness is something that any jury considers, including these military members. They've heard the entire case. They've heard Mr. Hamdan's defense case, which I can't discuss with you. They know who Mr. Hamdan is. They've had the whole case, and their verdict was to release Mr. Hamdan at the end of this year. It's my hope that Mr. Hamdan's case will be the last contested military commission, and that our country can return to the rule of law. I want to finally talk about some of the problems encountered just generally in establishing a new court system, because I think we're moving away from the suggestion that we can have military commissions. But now we're talking about a national security court, or at least there's a debate about a national security court. But a deficient criminal process by any other name is still a deficient criminal process. Whether you take me and the other military lawyers out and you leave this ad hoc tribunal now with an Article III judge presiding over that process, it is still going to be deficient justice. And the problems that we've encountered should dissuade anyone who would even endorse this idea. Now, in the military commissions, these trials take place in the context of the law of war. So that would be different in a national security court, but you can imagine that the issues will be somewhat similar. But in the military commission system, we're dealing with war crimes. So these crimes must take place on a battlefield in the context of an armed conflict. When did the war start? I mean that's a critical question that we still don't have the answer to. Some of those photos that I showed you, one of which was taken in April. It's a press conference in April of 1998. Now you will remember that the embassies were attacked in August of 1998. So were we at war with Al Qaeda, and should that have been evidence at Mr. Hamdan's trial? When it occurred, that photograph occurred before the embassy attacks. You know, one prosecutor actually told me, and I think he was only half kidding, that the war with Al Qaeda started in 1452. It was having something to do with the Moors in Spain. I mean, okay, good. Then it was a while ago. I'll just say. I was laughing too hard actually to really pay attention to what he was saying. But these are the issues. Mr. Hamdan, as you saw, the mortar rounds coming in is taken on a battlefield. But what about the terrorist financier who is in Dubai, who never leaves Dubai, who wires money to 9/11 hijackers or some other terrorist attack? Has he really committed war crimes in the context of an armed conflict on the battlefield? I mean, these are the issues that are being litigated at Guantanamo. What rights apply? Because the military judges have said that essentially only one sentence of the Constitution applies, and having read Boumediene, that can't possibly be the right interpretation of that decision. I'm not saying the entire Bill of Rights applies. Perhaps there's no right to a jury. Because we don't afford military service members that right, although I'm not even certain that that's a credible argument. And so we're going to litigate right by right, which procedures are deficient right by right through the entire Bill of Rights, essentially, and then the substance of the Constitution as well. So you can imagine that the appellate litigation, where we to keep the military commissions going, is going to last for decades. And no one is ever going to get justice under this system, not victims of terrorism, nor the detainees that are held indefinitely at Guantanamo Bay. And a national security court that deviates from those core values, those fundamental values that are enshrined in our Constitution is going to face the similar challenges, similar hurdles, and really endless litigation. And we're really dealing with discrimination here, because John Walker Lind, Padilla aren't subject, having come from the same organization, the same battlefield, as U.S. citizens, aren't subject to military commissions. We're dealing with foreign nationals. We're giving lesser justice to a category of individuals based upon national origin. Separate but equal was unconstitutional in our schools, and it should be unconstitutional in our courts. We should not have separate systems of justice, whether it is at Guantanamo Bay or in an Article III court in Washington, D.C. Finally, I've seen no compelling reason why we can't have why the courts, which are open and operating, according to Milligan, can't address the legitimate national security concerns. And I don't want anyone to take away from my remarks that there are not legitimate national security concerns. It's not the 9/11 report, but there certainly are legitimate national security concerns. For a handful of very dangerous men at Guantanamo Bay. Certainly not the 250 that are there fall into this category, but a much smaller number. We have SIPA, we have Military Rule of Evidence 505 in the court-martial context, which is modeled off of SIPA, to protect the government's interest in national security. And you see this. I mean, these are actually the answers of Khalid Sheikh Mohammed that we obtained. Now, we weren't initially allowed to see Khalid Sheikh Mohammed until after I was in the same room with him in June. But you see that the government was able to screen this. There is a redacted portion. We were able to see Khalid Sheikh Mohammed's answers. I mean, he was a driver, an auto mechanic. My job is planning terrorist activities. I was the executive director of 9/11. Hamdan had no knowledge of the operation or any other one, because you can imagine, and this is what the testimony that we were looking for, you can imagine how hard it would be to pull off an operation like 9/11, that terrible event in September of 2001, if the drivers and the low-level operatives, the employees, the personal employees of Osama bin Laden had been clued into to these operations. It just couldn't be done. The drivers were illiterate, and it disqualified them from such activities. And this is my favorite one. He essentially says that Hamdan's an idiot, and that he's a terrorist, and he wouldn't trust Hamdan with a terrorist operation. He says he's fit to change trucks' tires, change oil filters, wash and clean cars, and that's why Mr. Hamdan is at Guantanamo Bay 8 years later, even after providing such significant material support to the United States. I mean, in any other context, Mr. Hamdan would be living in Cleveland under an assumed name, John Smith, with his family. Paid from Osama bin Laden's pocketbook, not from the Al-Qaeda budget, which Ali Soufan testified was something. This is a government witness, testified as something significant, that bin Laden has servants, and it means something to be paid a salary. Like Mr. Hamdan was getting $250 a month, probably 6 to 10 times what he could make as a Dabab driver in Yemen, and he was paid. He worked for a bad man, admittedly, but he was not involved in any terrorist activities. And this is all I can say about this. This is that reference. And this is from the closing argument. I've litigated national security cases, one espionage case in the military context. To my knowledge, there's been no leak of classified information. I believe that the courts are capable of handling this, even if it has to be in a special facility like the courthouse that we have down there at Guantanamo Bay. That's not a justification for a separate apparatus, a separate set of courts. There are dangerous men at Guantanamo, as I said. We do face a challenge against terrorism, but we can meet those challenges in the same way that we've met adversity for the past 200 years in this country, by adhering to the fundamental values that forged this nation and made this nation great. And I'd be happy to take any questions. Professor, good to see you again.
You are I have a couple prong questions. Are you a career officer in the Navy?
Not anymore. No.
Well, I guess you answered the second aspect.
No, go ahead.
Second aspect of the
Yeah.
question was, do you, has there been any, you've obviously been a thorn in the administration's side. Has there been any, let's say, problems in your career advancement as a result of this work that you've been doing on behalf of the defendants?
I don't think so. I mean, the opportunity is still there for me to continue a career. I'm leaving for personal reasons, not related to Guantanamo at all. I mean, I think you'll see that mentioned about Charlie Swift, my predecessor on this case, and I'm hopeful that there won't be those repercussions. And I have faith, at least in the Navy Judge Advocate General, that there will not be repercussions. He has been incredibly supportive, and in fact, he sent the handful of military justice specialists that he has, primarily to the defense side, and I think that's a positive sign. Sir.
Suppose we do come up with a national security court. I just have two questions. Besides, in regard to the substantive offenses, besides nixing sections 25 or B25 and B28, the material support for terrorism and conspiracy charges offenses, would you make any other substantive changes to the list of offenses? And do we need to modify SIPA for this for a proposed national security court?
I think the offenses under National Security Court, you know, that's one of the shocking things about this is we don't have any details on what this court is supposed to look like, what the crimes are, or anything as this is being discussed. But my understanding is that the crimes would be federal crimes. So you would look at 2339 Alpha, 2339 Bravo, material support for terrorism, and material support for an international terrorist organization, respectively. And then any number of offenses using the special maritime jurisdiction of the United States. So these cases could be prosecuted, many of the cases could be prosecuted in a federal court using SIPA. And I don't know, I haven't seen a convincing argument yet as to why SIPA would be ineffective, why SIPA could not handle these cases. We've been litigating cases, under SIPA since the late 70s, MRE 505, and I haven't seen any attempt to, that I'm aware of, at least with MRE 505, to even modify that whatsoever. I mean, and significant cases of espionage. I mean, I was talking with Professor Strasfeld before about Cook v. Orser, a famous case, at least in the late 70s, early 80s, dealing with an Air Force lieutenant who was spying for the Soviets. I mean, we've litigated these cases. These procedures have been tested, and we shouldn't abandon them at this point. Ma'am.
Yes. Thank you so much for sharing your time with us. I wonder, given, I say Romanian decision, what are its practical repercussions, effectively speaking, when the military commissions continue functioning despite the Romanian?
Yes, they will continue functioning, and they have continued to function. I mean, Hamdan's case took place after Boumediene. The practical repercussions will come on appeal. So we are now anticipating an appeal before the Court of Military Commission Review. If we lose there, we can go to the D.C. Circuit, then to the Supreme Court of the United States. And that's what I'm saying is that this is just going to result in endless appellate litigation because we will go up to the Court of Military Commission Review if they say, you know, one, in the way that the way that the courts decide issues, they avoid addressing the broader issues. So you'd have one right discussed, and then that would reverse a number of convictions, and you'd have rehearings, and then you'd go up on the next right. And that's the problem that we face in creating new courts and new laws. So right now, there have been no repercussions. Military commissions continue, but certainly, I mean, I spent 4 years as an appellate lawyer, and I've never seen anything as wonderful from an appellate standpoint as the 4,000-page transcript in Mr. Hamdan's case. I don't even know where to start with the appeals. Ma'am?
With the radical change that's anticipated in Washington in January, it's sort of a two-pronged question. How much of a change do you think
I think the change is, at least with the stories that have been reported in the media in this past week, is going to be pretty, it's going to be pretty dramatic. And I would like to see the military commissions close on January 20th or 21st of next year. And they need to close at that point. If for no other reason, the practical consideration that the 9/11 case is moving towards trial, and we'll be back in Guantanamo December 8th litigating more motions before that case. But there will be a trial in June, July, August, barring any major setback. And if jeopardy attaches in that case, then you've lost one of the central reasons to hold terror hearings. I mean, why would you allow if it's true, the allegations against those men to go forward in this substandard system of justice and then go after the cooks, the drivers, the stable boy? I'm actually told we have the stable boy at Guantanamo Bay. It needs to happen soon. I mean, for many reasons, but if for no other reason than to ensure that justice is done in a federal court. Sir. They're chosen by the convening authority from a pool of military officers, and you know, I can't say enough about the military jury. Obviously, in Mr. Hamdan's case, that is the one bright spot, and again, another reason why military justice, I think, is far superior. You know, these are senior officers, military officers. Many of them have graduate degrees, and when they saw the evidence against Mr. Hamdan, the government overreaching. I mean, the government actually said in its closing argument that Mr. Hamdan was the last line of Al-Qaeda's defense. That's one quote, and the other one was a Bayat-pledged Al-Qaeda warrior. And the jury looked at that and gave a 66-month sentence. So that is one of the bright spots. I don't know that we have much to complain about in the way of the military courts call it a blue ribbon panel, and I think that's quite accurate. Sir. Okay.
Do you have adequate resources for your defense?
No, and we will not. You know, I can't say enough about the law firm Perkins Coie out in Seattle, because they've spent $3 or $4 million in billable hours on Mr. Hamdan's defense. They paid for experts when the government refused to do so. You know, from resources with respect to investigations, with respect to experts that we needed to actually litigate the case, we didn't have any of those things, and we had to fight tooth and nail to get what little resources that we ultimately did get from the government. So that would be another positive aspect that hopefully an Article III court could deal with. I will tell you that in the 9/11 case, the government just denied my request for a mitigation specialist in a capital case. I mean, how anyone can suggest that a defendant doesn't get a mitigation specialist in 2008 in a death penalty trial, it shocks the conscience. And yet those are the type of resource hurdles that we have. Thanks for your time.
With any luck, you won't have many more flights to Guantanamo, but for the long flight, as a gift of the Institute, for all the coffee that you may be drinking.
It's cold on a C-130, so this will be good.
So thank you very much, and again, please join me in thanking Lieutenant Commander.